a date for the confirmation of charges here at a later stage. With regard to the first point, I recall that Mr. Duterte has received a copy of the warrant for his arrest, and that a redacted version of the prosecutor's application for the issuance of the warrant of arrest is public. I will now ask the court officer to read the charges against him. The charges will be read in English. Please, over to you, Madam Courtroom Officer. Thank you, Madam President. Your Honours.
On 7 March 2025, pre-trial Chamber 1 concluded that there were reasonable grounds to believe that Mr. Duterte is actually drug pushers or thieves killed by members of the DAVA 2011 and 2016. B. Murder of at least 24 persons, allegedly criminals, such as drug pushers or thieves or drug users.
Grabe, 24 persons lang pala yung pinatay
members of the
ni
Philippines
Duterte.
law enforcement, sometimes with the assistance of persons who were not part of the police, at various locations in the Philippines between 2016 and 2019.
Merci beaucoup, Madame. Thank you, Madam Courtroom Officer. Mr. Duterte, I'm not going to ask you to stand up because I know your condition, so I'm going to allow you to remain seated. You have just heard the reading of the charges, which are in accordance with the content of the arrest warrant you received. This means that you have been informed of the crimes of which you are accused. And this concludes the examination of the first point mentioned above. I will now turn to the second point, which concerns your rights as a suspect before this court. I will summarize some of these rights, which are of particular importance at this stage of the proceedings. Those rights are as follows. You can benefit from the assistance free of charge of a competent interpreter and benefit from the necessary translations to meet the requirements of fairness. You have the right to have the time and facilities necessary to prepare your defense and to communicate freely and confidentially with the counsel of your choice. You have the right to remain silent, and you cannot be forced to testify against yourself or to confess guilt. You can also make statements in your defense without taking an oath.
So 24 lang yung kaso na isinampapal yung
provided for in the statute. The prosecutor must disclose to you as soon as practicable evidence in his possession or at his disposal that shows or tends to show your innocence or to mitigate your guilt, or that could undermine the credibility of the evidence against you. At the confirmation of charges hearing, you can contest the charges, challenge the evidence presented by the prosecutor, and present evidence. There will be no trial if the charges are not confirmed or if the proceedings against you are completed. You have the possibility to make an application for interim release pending trial. And finally, Mr. Duterte, you have the right to be informed as soon as possible and in detail of the nature, cause, and content of the charges in the language that you fully understand and speak. Counsel, have you understood?
We're listening, ma'am. We're listening, and before it ends, may we be allowed to present a manifestation on the circumstances behind the delivery of Mr. Duterte in this chamber.
Oui, maître, je dois d'abord demander...
Yes, counsel. this is as part of the procedure, and as we've said since the very outset, I need to ask Mr. Duterte himself to make observations as to the condition of his surrender to the court and the conditions of his detention at the detention facility of the court since his arrival. If he can please tell us these details.
Thank you. Can I...
Oui, maître. Oui.
The presiding judge, yes, counsel.
Please. 2 days ago, the whole world has witnessed the degrading fashion in which a former president of a sovereign country was bundled into a private aircraft and summarily transported to The Hague. To us lawyers, this would be called an extrajudicial rendition. To the less legally inclined, it was a pure and simple kidnapping. My client was denied all access to the legal recourse in the country of his citizenship, and this all in the nature of political score settling. Two troubled entities struck an unlikely alliance. An incumbent president who wished to neutralize and choke the legacy of my client and his daughter on the other hand, and a troubled legal institution subject to delegitimization and desperate for a price cuts and a legal show today on the other hand. With this in mind, it is not surprising that my client was abducted from his country. ICC private jets do not drop out of the thin air. That jet which received my client was coordinated in advance. The UAE is not a state party to the ICC and has no obligation to cooperate with the court. Yet my client sat in transit in that country for more than 5 hours. I invite the registry's representative to present today in court to explain to the judges exactly how they believe this transfer was anything other than a gross abuse of process. Given the precipitous arrival of my client, an elderly man with debilitating medical issues, hard of hearing and poor of sight, he was taken to a hospital for observation. Only this morning have I met him for the first time with less than an hour to discuss legal issues. I have not been able to present him with a hard copy of the arrest warrant because we were not supplied with such. I have not even been able to explain to him what the prosecution requested when seeking the issuance of the arrest warrant. This is because the chamber only established a redacted version of the prosecution request last night. Other than to identify himself, my client is not able to contribute anything to this hearing. Most importantly, he is not able even to tell you that he has been informed of the charges as contained in the arrest warrant for a reason more pertinent to which I alluded in my written request to this honorable pre-trial chamber this morning, and which is confidential in nature. Accordingly, I repeat my respectful request, which was rejected this morning, to postpone the substantive aspect of this hearing to the next week, when I will have the opportunity to sit with my client and to explain to him what a confirmation hearing is and what the disclosure is, and how the prosecution alleges that he committed crimes. I thank the court for its attention and regret to say that I do not have instructions to continue my submission any further today. Thank you.
D'abord, concernant
Thank you, counsel. Now, with regard to the health issues of Mr. Duterte, I believe that the court has taken specific measures with regard to his health situation, and I note that subsequent to his arrest and when he arrived at the detention center, the court's doctor was of the opinion that you were fully mentally aware and fit, and that you have undergone further checks and tests at the detention facility. And when you broached health matters, that's saying that you were not able to come to the hearing, the doctors who consulted with you were of the opinion that Mr. Duterte was not in a position to come to the hearing physically, but that if he gave a written permission, he would be able to take part via video link. Now, that is with regard to the health matters that you just mentioned. They are very important, especially concerning the matter of age. Now, with regard to the rights of Mr. Duterte, we have before us the registrars or the registry's report that says
Bayan.
the warrant of arrest in the English language, and that he is very well versed in the English language. Once again, you have the possibility of these charges being read in English, which was the case today. I have read to you in the French language the rights that he has, Mr. Duterte, before this court, and I'd like to specify once again that this is an initial hearing. In order for these Mr. Duterte to be aware of his rights
So, dito guys, sa part na to,
of jurisdiction of the court, these proceedings leading up to the actual